Our next matter is 2018-P0842, HI versus MS. This matter also is partially impounded. Because it's partially impounded, if you could find a non-name way to refer to the parties, either the initials or first initial or ex, husband or ex-spouse, ex-wife. Thank you.
Members of the panel, may it please the court, I am MS, the appellant pro se. I am here on the lower court's 209A abuse prevention order entered against MS temporarily on September 14th, 2019.
Could you just speak up just a little bit?
Yes. 2019, and again at a 10-day hearing on September 29th, 2017. The handling of said 209A orders by the lower court is inconsistent with Massachusetts rules, case law, and statutes. Combined and properly applied, they warrant a complete dismissal of this case, and to vacate the unwarranted 209A abuse prevention order nunc-pro-tunc to remove any and all records of this matter. The parties have a history with the lower court going back to 1999, which has since grown to more than a 30-inch deep docket. Considering the magnitude of the lower court records, it is remarkable to note that appellee HI has not put forward any lower court facts, findings, orders, judgments, or witnesses to substantiate or corroborate the exclusively fraudulent allegations she has made against MS in her affidavits and hearing testimonies. Upon review of lower court records and facts going back to 1999, it is obvious there is no history of threats, violence, or abuse between the parties. It is found in HI's testimony to the GAL, Volume 3, page 16, where she states there was no physical violence in the relationship. HI's larger 209 action against MS is entirely fabricated and malicious. It is intended to bias the lower court against MS prior to the January 19th, 2018 trial on HI's then pending complaint to reduce, terminate her child support obligation to MS. Volume 1, pages 99 and 100.
Was the GAL report offered to the judge at any time before he either issued the original ex parte order here or when he extended it after the...
No, nothing was brought forward. The judge, Justice Cronan, was new to the parties. And Justice Cronan was new to the parties. We'd only been before him one time prior to that for a pretrial conference.
But did you offer to hand up a report? I thought you offered to hand up some documents. I did. In my motions, I included orders from Justice Harms, who had been our case justice from 2004-2012, identifying HI's conduct before the lower court at the time that our son's custody was removed from her and granted to me. So at that time, that was following 2 GAL investigations. The HI says that you had filed paperwork in the probate court indicating that you knew HI had changed the locks on the premises. Is that correct?
That is not true. If you read the motion, what HI does in her motion, I'm sorry, let me just find, I have it here. 1 second, please. Let's see. HI states in her September 29th, 2017 hearing testimony, which is Volume 1, page 74, lines 2 through 9, that MS's recent motion of September 11th actually states that he wants to get into the house. Had the lower court, in fact, read MS's September 11, 2017 motion, it would have found the motion solely requested the party's son's access into HI's house, along with a police officer accompaniment. Nowhere in said motion is access into the house stated or indicated for MS. It just isn't. This was something I was doing on my son's behalf because she had locked him out of the house.
So the GAL report was attached to your motion to vacate?
No, it was not.
So when did you present it to Judge Cronan?
The motion to vacate, I brought at the hearing on September 29th. And I handed it to the court officer, who in turn handed it to Justice Cronan. Justice Cronan never looked at it. He held it up like this. Once the officer gave it to him, looked at me, pointed at it, he took it, he put it down on the desk, and did not look at it again. Then when I went to cite what was in there, such as Judge Harm's prior orders, speaking to H.I.'s embattled nature and all her allegations at that time, why the GAL was insecure, intimidated, disingenuous, shouldn't be heeded to in that. Judge Harms at the time just identified her as embattled, and she continues, unfortunately, that way to this day. There are, within her affidavits, many allegations put forward, and they are all refuted in lower court records. When I offered to put anything forward, the things that, let me find my notes. If you look at the transcript from the hearing, the types of things that the lower court justice was saying was he wasn't going to relitigate the divorce. This was not about the divorce. The divorce was finalized on May 1st, 2006. He said he wasn't going to hear any history. Unfortunately, some of that history was recent. In effect, he precluded anything prior to his involvement in the affidavits put in front of him. The affidavit that she provided to the court on the 29th was given to me when I walked into the court. I had 5 minutes to read it. The hearing then began, and I was asked if I read it. I looked at it, but I had no time to absorb it, nor did I have any time to pull anything together to refute any of the allegations. Also, at no time did the lower court insist that she put forward any evidence, witness, any records from any of the lower court records to substantiate any of her groundless allegations. She also said to the court that I violated the temporary restraining order by having a private investigator follow her. What she didn't tell the court is that she had already gone to the Hanover Police Department 2 days after the hearing, the first hearing, which I believe was on the 17th, I believe, or the 14th, I'm sorry, and they told her specifically that there were no PIs registered at that time with the town of Hanover. What she didn't put forward, she claims that there's all these times I tried to break and enter into her home, yet at no time during that 1 month period between when I first filed the motion for my son to retrieve his belongings from her home until the abuse prevention hearing, there was a full month that passed, and none of that time, despite all her allegations of all the occasions I went to her house supposedly to try to break in, there were no police investigations done. When she came, she claimed her brothers had been staying with her to protect her. Neither of her brothers came forward to testify for her as witness. Essentially, this was done on allegations.
Sir, this could be, the judge could enter an order just based on her testimony if the judge believed her testimony and didn't credit your testimony. She's not obligated to bring forward other witnesses. So looking at the evidence that was before the judge,
yes.
What mistake do you think the judge made in either weighing that evidence or not letting you make your case or anything else that you want to tell us?
I think when you look at my brief and the case law, cases that I cited, it's very clear that my rights were violated, that I should have been allowed to bring these items forward, that if she was going to make allegations against me, they should be substantiated. It can't just be pages and pages of emotional rants, and somehow that's credible. Had he read simply the motion that I had brought on the 29th, the one prior from the 11th, and he looked at the orders.
I just want to pause you because I want to make sure I understand you.
Right.
Were there ongoing proceedings related to your divorce?
Yes. No, not the divorce.
So the ongoing proceeding was related simply to your filing a motion for your son to have access to the house?
Yes. However, there was an action with the court that was open at that point still with Justice Ulwick that was concluded in January 2018 from a trial in September 2015, and that's part of the court record. We were also in front of Justice Cronan because on H.I.'s complaint for modification, where she wanted to be essentially relinquished of her child support obligation or to have her child support obligation reduced. Those were the matters in front of the court during that period of time. So it was with two justices because of transition. Justice Ulrich had already been relocated to Salem, and H.I.'s attorney at the time continued to file motions citing different case law that he thought gave her some sort of grounds to have the child support order adjusted. In her final order, the amended order of January 2018, it's very clear that she was not going to amend it and why. And subsequently, when we did go to trial with Justice Cronan, he in effect, he kept the child support order in place. What H.I. is unhappy with is she owes me about 4.5 years still of arrears child support, and she's very unhappy about that. Why would I risk anything I've done over the course of my life, my name, my relationship with my children and my family, to do anything that this woman has alleged? There's a reason we are divorced, and I have not spoken to her since September 2004 because of this sort of behavior. And given the history with the court, Justice Cronan should have done something more than just acted on her allegations. And just the appearance that she's upset or whatever, anyone can act like they're upset. You know, and if you read the affidavits, it's deep, she goes into bizarre detail about all the things I've supposedly done, yet she puts no evidence forward for any of it. And there are records with the court, which I've attached to my brief and to my appendices, that directly refute everything she's alleged. Thank you.
Thank you.
May it please the Court, Attorney Mara Kiefer here for the plaintiff appellee H.I. The issue in this case is whether or not the trial judge abused his discretion in extending a temporary restraining order for 1 year. In support of that, the plaintiff filed two affidavits, an original one and a supplemental one, which was handed on the day of the hearing, and testified at the hearing. The appellant did not call any witnesses himself, nor did he ask for a continuance. On the day of the noticed hearing, he filed a motion to vacate the ex parte order and attached two custody orders dated 2011. The judge denied his motion to vacate the ex parte order and wanted to continue with the hearing on extending it for 1 year. So the motion to vacate the ex parte order was denied. The appellant insisted on discussing these 2011 custody orders and what happened in the parties' decades-long custody and divorce litigation. I thought the judge was very good at the hearing and tried repeatedly to direct the appellant to focus on whether or not he should extend the temporary order for 1 year. And despite the judge's several attempts to get the appellant to focus on an answer why these should not be extended, he insisted on discussing these 2011 custody orders. Now, the judges in these 209A hearings are free to consider or disregard evidence within their discretion. What they cannot do is make a decision, I'm not allowed to view this as an error of law, it's hearsay when it's not. There's cases to that effect. That's not what happened here. He made a decision within his discretion to not consider these 2011 custody orders and instead focus on the allegations, which consisted of an allegation of serious physical harm that was committed upon H.I. during the marriage, where her arms were twisted behind her back, where she was pushed down the stairs, incidents of animal abuse, emotional abuse.
What year was that? I had a little bit of difficulty determining from the record what year H.I. alleged that happened.
Yes, and she did not put a date on it. She said during the marriage. And
that ended in 2004?
Correct.
So correct. Sometime prior to 2004?
Yes, sir. Yes, I would assume.
Okay. After that, is there any evidence in the record of either any physical abuse or any threats to do physical harm?
Yes, she details in her affidavit, there's a timeline, they were in court on August 7th, which was within a month.
Remark about your going down?
Yes.
All right. Is that unambiguously a threat to do physical harm, or is it, assuming the remark was made, is it a comment about you're going to lose this hearing, or what is it exactly?
I think her overall testimony to the court below was that she was scared of this person, and that was part of the totality of circumstances, one of many things in the course of their long history of a volatile relationship. And if you read the testimony that was at the hearing, she repeatedly said how scared she was of him, how much he hated her, and evidenced his extreme hatred of her over the years, and it was through clenched teeth, and he was extremely angry. So it was an extremely angry and unsettling threat to her.
Is there any, I couldn't find an indication in the affidavit of when that court hearing was, when these remarks allegedly were made.
I have that it was, she put down August 7th. I can find that in the supplemental affidavit if you like. If you look on the supplemental affidavit,
well, the account of the hearing was in the original affidavit, wasn't it? And then there was a...
yes, sir, you're right, the original affidavit, so... August 7th, September 8th.
Okay, yeah, I see. On pages 42, 43.
Sir, yeah.
The last time we were in court on August 7th, 2017, it was evident, et cetera, et cetera.
Yes, sir. And so to continue with the timeline, so then on August 17th, she testifies and puts in her affidavit that she looked to her like her locks were tampered with. And then on September 11th, she receives, let me back up. On September 8th, she also sees that the locks on her basement door were tampered with. And then 3 days after that, she's served with a motion from the appellant to gain access to the house, to get things for their adult son, who's a senior in college. So nonetheless, she's served with this motion 3 days later. Can she prove he accessed the house? No. But this is the totality of the circumstances in combination with their long-standing volatile history. On September 14th, she submits her affidavit and gets the temporary restraining order. The following day, the Hanover police call her to tell her that they served the appellant with the restraining order. She states three days after that someone is following her, and that she has been followed and tracked in the past, and that she is scared of this person. She had made credible allegations of serious physical harm in the past, and also testified and the judge credited her testimony that she had genuine fear from this defendant based on their history and what happened within a month of this hearing. And so the issue here and the concern that we have from a legal point of view is that we understand that this is pro se, but it appears today even that appellant is testifying and tendering things to this court that are not part of the record on appeal, that were not part of the evidence below. And so to talk about all of this GAO report, all of these other things, no continuance was asked for. The two issues here was he granted a fair hearing? And he was absolutely granted a fair hearing. The judge gave him multiple opportunities, in fact, tried to help him, to get him to focus on the issue at hand, which is should this be extended for a year, and it's not, why not? And I think it's really notable that he never specifically denied the physical abuse at the hearing. He never actually denied breaking into the house. He never denied telling her she's going down and what that meant or didn't mean. In fact, he makes a statement that he had not, in his brief, that he had not spoken to her for years, which is not true, or at least it's contradicted by the plaintiff's testimony that he told her she's going down when they saw each other a month before this restraining order. The reason this was filed was clear to the judge below, that there was these events are building up and building up, within a month, and she's getting scared, and there's this past history, and the judge was satisfied, and he made credibility determinations regarding both reasonable fear of imminent harm and also past account of physical abuse. And if you look at the cases, whether the physical abuse is within 4 years or 4 days, the courts say that someone doesn't have to wait for another incident of physical abuse to occur to warrant getting an order of protection from abuse. And so the issue here is, did the judge abuse his discretion when he granted this? And he made credibility determinations at the hearing. He had the opportunity to see both of these people and what they said. So he was in a much better position than us to make that determination. And this is a civil proceeding. And the case law tells us that a judge's credibility determination should be given great deference on appeal. I filed a motion to strike these extraneous pleadings, numerous pleadings that have been filed by the appellant that go back a decade, these GAL reports, emails, police reports. These things could have been brought forward below pro se, or it could have filed an attorney, but that wasn't done. It's not part of the record. It wasn't preserved for appeal, and it would be really inappropriate to consider the record appendix on this appeal.
Presumably they could have been if they weren't filed in connection with the what I gather is the extension or the hearing on whether to extend the order that occurred in September of 2018?
Yes, sir.
And that's the subject of a separate appeal that's not been consolidated with this?
Correct. There's another one going on, and this actually expired in 2018, and I understand it's not moot and that, this appeal can continue. I do think that the case law says the ex parte orders are subsumed when it's extended, and therefore the motion to vacate is, in fact, moot for purposes of this appeal. But the great concern that we have from a legal perspective is this case and cases like this need to be decided based on what happened below, based on the evidence that was adduced, and not emotional pleas after the fact that whether they occur here or these multiple filings with documentation that is not part of the record on appeal. And so that's why we filed a motion to strike, because it's inappropriate and it violates the rules of appellate procedure. Pro se or not, we're still all supposed to follow the same rules of appellate procedure. Now, they do provide for a more relaxed environment during these 209A hearings. And but the cases all say the same thing. At the end of the day, it comes down to, was there fundamental fairness? Did the person get a fair hearing? And did the judge commit an error of law or abuse his discretion? And if you read the transcript, he really didn't. He gave both parties an opportunity to have their day in court to say, tell their side of the story. And he was within his right, the judge was within his discretion to not want to consider the 2011 custody orders. That's what was attached to the motion to vacate, and nothing else. Nothing else was attached. No other witnesses were called. And the judge was satisfied with the plaintiff's burden of a preponderance of the evidence to establish that she warranted an extension of the order.
How long was this hearing?
How long was it?
Yes.
I don't know, Judge. I have the transcript right here. The judge took testimony from both parties, and it looked like to be a very short hearing.
8 minutes, it looks like.
I'm sorry?
8 minutes, it looks like, from the beginning and end times on the transcript.
I suspect that one of the reasons it was so short that, despite 3 requests to the appellant of tell us why this shouldn't be extended, he just insisted on discussing the 2011 orders. When he finally started to respond to the judge's question, he never denied these allegations. He says they're nonsensical, they're groundless, and I didn't do anything wrong. And in his appeal, he says, he should have read the GAL reports, which weren't part of the record, because they all speak very highly of me. So it's an effort to say, I'm a really great guy, and he should have believed me and not the plaintiff. And I submit that even if all of these documents were actually entered into evidence, which we're not allowed to consider on appeal, but even if they were, the judge still would have been within his right to make credibility determinations based on what was in these two affidavits, based on the testimony at the hearing on whether or not there was a reason under 209A to extend the order for 1 year. And I submit that he did not commit an abuse of discretion or an error of law that was pointed to in any of the appellate arguments or preserved for appeal. I think the judge did a good job hearing the case and gave everyone a fair hearing. And that his ruling should not be disturbed on appeal. Have any questions?
No.
Okay, thank